From LA Law to Law and Order, we've grown up watching TV juries put bad guys away. But guess what? Television is guilty of impersonating reality because most criminal convictions, close to 97% in fact, have nothing to do with the jury, and it's plea bargaining that really drives the legal system. Some say plea deals are essential and unavoidable, and that without them, court calendars would be swamped and the wheels of justice would turn even slower. But many defense attorneys argue that the reliance on plea bargains leaves open the process to abuse. So are plea bargains a necessary evil, as Justice Antonin Scalia has said, or are there ways to improve the plea deal process and thus curb those potential abuses, like having a jury approve the plea bargain? Joining me in the studio is former Manhattan prosecutor and current Brooklyn litigator Amir Benno from Amir Benno & Associates. Thank you so much for coming back to BK Live.
Great to be here. Thank you.
And we also have with us Slate editorial writer Leon Nefka. Thank you also for being here. And I just kind of want to jump right in because we have a general idea of why we have plea bargains, right? I mean, they provide a little bit of leverage for prosecutors in order to persuade suspects to give information, for example, so they can get a bigger defendant. It also allows for the criminal justice system to kind of move forward a little bit, reduce some of the backlog, and it does give defense attorneys an ability to allow their clients to get a lesser sentence. So what are the problems with plea bargains? I'm going to ask you, Amir.
Well, I think first, all the cards are in the prosecutor's hands. And the prosecutor comes into a case, obviously, knowing far more than the criminal defense attorney. The criminal defense attorney has to advise his or her client as to whether it's prudent to take an offer or not to take an offer. And sometimes the client can, by taking an offer, can save themselves years on a sentence. But when there's an imbalance in the knowledge base, and it's a very uneven playing field, and it all rests with the prosecutor, then you can't really counsel your client properly as to whether or not they should pursue the case and take it to trial and get their day in court, or whether they should avail themselves of an offer. And so therein lies the problem that and there's a few problems. That's the first problem. The second problem I'll just point out is that a lot of draconian sentences, there are mandatory minimum sentencing guidelines that really take discretion away from the courts, and they vest it in the prosecution. And so when you're faced with a huge sentence, there's a lot of pressure onto a criminal defendant to plead guilty, even in cases where they may in fact be innocent.
Now, you've played both sides of the fence here. You've been a prosecutor in Manhattan, and now you're a defense attorney here in Brooklyn. So looking at it from both sides, what was it that you were looking to do as a prosecutor when you went into the plea bargain negotiation process, and how do you now, seeing it from a defense attorney's point of view, work on the plea negotiation process in that respect?
Well, as a prosecutor, I was with the Manhattan District Attorney's Office under Morgenthau, and my experience there was wonderful. My experience there was that the office had tremendous integrity, and that we weren't looking to just secure convictions, which I think there's been more and more of a trajectory until lately of just trying to build up statistics and get convictions. And I think often what prosecutors will do now, so my experience there, first of all, was to really try to do what was fair. I can't say that what I did is necessarily representative of everybody, because there certainly are prosecutors who just want to get the conviction, and they don't want to disclose to criminal defense attorneys oftentimes that perhaps a complainant is not cooperative, or perhaps a complainant is dead, and they can't prove their case, but they have a suspicion that the defendant is in fact guilty, so they hope that any sentence is better than no sentence, and so they try to make a plea offer that the person will take. And obviously on the other side, the defendant and the defense attorney are unaware of the cards that the prosecutor holds. And therein is the problem. I mean, it's a game of poker. Really, who's going to stare down who? And it's, I guess you'd call it more of a game of chicken. Who's going to blink first? And the stakes are very high. So as a criminal defense attorney, you have to be very cognizant of the fact that these people are people's fathers and mothers and children, and they have families and jobs, and if there's an expense to take the case, and many times people lose their jobs during the pendency of a prosecution, so
These are all the factors that would be brought in as to why someone would be more persuaded to take a plea deal rather than hearing everything out, seeing what the prosecutor has as far as evidence is concerned. And so you're saying that that's kind of what allows for this opportunity for abuse, because like you said earlier, a lot of the cards are left in the prosecutor's hands.
Yeah, I mean, I'd be careful to say that that's abuse in and of itself. I just think that's the nature of the system, which I think is clearly an imperfect system. I mean, abuse to me connotes that there's been some suppression of evidence or something to kind of coerce in a more coercive way through some sort of real misconduct to encourage a defendant to plead guilty, as opposed to the kind of normal factors that, well, if I go to trial, I'm going to have to pay the attorney, a ridiculous amount of money, or I'm going to expose myself to lengthy sentences and be away from my children. Those are the natural kind of human factors that play into this that you have to consider. And I think the prosecution tends to not look at those factors. They tend to look at this as a black and white. This is a case, a criminal case. They're charged with prosecuting, and there's a lack of humanity in realizing, well, these are people, and so.
Right, so I want to bring Leon into the conversation a little bit, because so we hear from Amir a little bit of some of the problems associated with the plea bargaining process. So what can we do to fix this, some of the solutions? I mean, in the Slate editorial piece that you wrote, you noted that one option being proffered is to put the plea bargains in front of a plea bargain jury. Tell me a little bit about that.
Right, so it's kind of a fanciful idea dreamed up by a law professor. Her name is Laura Appelman. She teaches at Willamette College School of Law. She's not, in the courtroom, so she's sort of not dealing with necessarily
theory rather than the practical application.
Sure, and there, I think as we'll discuss, like there are a lot of practical limitations to incorporating juries of lay people into the plea bargaining process. The whole point of plea bargaining, in a way, is to make the whole process more efficient.
Right, and by having a plea bargain jury, for example, that just adds another element to a system where we're trying to reduce the backlog.
Yeah, and it might sort of, it would likely slow it down sort of to an impossible extent. But like the reason to kind of think about it is that it reminds us that, why do we think of jury trials as sort of like the ultimate sort of form of justice? It's because there's these 12 people there who are, representatives of our community. They can hear the case, they can hear the facts, and they can decide. It's not two professionals, not two lawyers kind of doing,
hashing out the technicalities
precisely.
Of the law and that sort of thing.
Yeah.
It's more fact-based and evidence-based, and really kind of a lot of times with juries, and you would know, giving closing and opening statements, it's about moving the jury to understand the motive for a crime and that sort of thing.
Yeah, and I think we want to believe that lay people have a voice in criminal convictions, and so I think the idea of introducing a jury into the plea bargaining process is to sort of give people, like regular people, a voice in how this plays out, and the fact that it happens 97% of the time sort of just underscores sort of how absent that voice is in our current system.
Yeah, Amir, what do you think about this idea of having a plea bargain jury? As a defense attorney and as a former prosecutor, is this something that you would recommend?
I think what Leon said, the adjective he used was fanciful. I wouldn't. But that's not to say that it hasn't highlighted an issue that needs to be explored more, which is why are innocent people pleading guilty? Or what is the coercive effect of putting all the power in the prosecutor's hands on a defendant pleading guilty? So I think that needs more further exploration. But there are so many legal and factual problems, I think, as a practical matter and as a legal matter with implementing a jury. First of all, what are the rules of evidence? What evidence would be put in front of this jury? Who has the burden of proof? And I think you'd see this huge magnification of litigation as to whether or not there was a proper plea. And pleas are, frankly, an intensely personal issue. I mean, like I said, there's a lot of personal factors that really come into play. Family issues. It's something that the defendant really needs to go home and speak to their loved ones about. It's not something that I think should be vested in the hands of a jury of people who are meeting this person for the first time. But what's interesting, and Judge Rakoff, who is a Southern District judge, a federal judge, has proposed not a jury system, but something equivalent to what's done in the civil sphere in federal courts, which is have a magistrate judge. In the civil arena, magistrate judges will preside over mediating settlements between the plaintiffs and the defendants in the case. And he's essentially proposed an analog to that in the criminal sphere, having a magistrate judge. I think
so like an arbitrator of sorts kind of analyze the plea deal? I mean, what would the magistrate's role be in that process?
Right, so to mediate it, not so much to arbitrate it, but I think to hear from both sides, there would have to be, and I think some of the rules have to be tweaked, or the contours are really ill-defined right now, but would have to be defined so that there wouldn't be a sacrifice of attorney-client privilege. But hearing from the defendant, hearing, the things that the defense attorney would hear from the defendant, and hearing what proof the prosecutor has. And usually what's done in the mediation of civil cases is one side goes out of the room, judge hears all of the information from the other side, and then sends that side out and brings the adversary in.
Right.
And in that way, the judge might be able to make a recommendation then to a district judge without involving the district judge in the actual, learning the facts of the case or compromising the defendant's Fifth Amendment right. And say, look, this is my recommendation. It's a weak case. I recommend dismissal. I recommend that there be a plea, and this is the plea that I recommend. And in that way, you have somebody who's trained in the law and who's trained to apply facts to the law. The magistrate,
as opposed to layman and to jury. So hearing this option, Leon, and I know that you've written a number of editorials on the subject of the criminal justice system, does that sound like a viable way to approach this process? So instead of having 12 members of a jury come in, having a magistrate judge, kind of a lower level federal judge or judge, assess the situation, assess the plea bargains, and make a determination based on that.
Yeah, I mean, I think it has the advantage of being a much more realistic proposal.
Yeah.
Judge Rakoff is someone who is in a position to perhaps even, make something like this happen on a trial basis. So it's definitely exciting in that way. The one thing it kind of lacks, you could say, compared to the plea jury idea is that you have a professional there, right? So the whole reason we like juries is they're just like us. They have sort of a common sense of justice, right? Like they can they're not there to think about all the technicalities. They can hear the terms of a deal. They can hear, oh, here's a guy who committed, is accused of crime X, but he is actually charged with like 13 different violations that the prosecutor has brought in order to create a very long sentence that they can threaten the defendant with. So you hear, the jury hears that and they say, well, that's not fair, and maybe they send it back at that point.
Wow. So I think that this is interesting as far as the numbers of proposals that are being kind of put to the table with regard to how do we address the plea bargaining, not crisis, but the abundance and over-reliance on plea bargainings, and how to make it a much more transparent, fair system for all parties involved. So I want to thank Leon for coming down, and of course Amir for joining us at our roundtable. Thank you again.